Good evening, everybody. You're all very welcome tonight to our meeting on jury trials in the criminal justice system. It's part of the series on justice, which we run with BPP University and their law school. I'm very grateful to Peter Chris and Richard Simmons from BPP for being such a generous host tonight, but I hope you haven't taken too much and you will concentrate on the proceedings to follow.
And I thought I'd start back in 1670, in the August of that year, when two Quakers, William Penn, who of course famously went on to found Pennsylvania, after whom it was named, and William Mead, and they stood in front of the Religious Society of Friends, the Quaker meeting house in Gracechurch Street, which is just over in the city, and they delivered a sermon. They preached in a public place on the steps of this meeting house. They were arrested and charged with causing an unlawful assembly in violation of a piece of religious discrimination legislation, the Conventicle Act, which essentially prevented religious assemblies other than those from members of the Church of England. So it was a deliberate piece of religious discrimination. And the maximum you could address was 5 people. The jury found them guilty of speaking in Gracechurch Street, but wouldn't go any further. The judge pressed them and wanted to add unlawful assembly, and the judge got angrier and angrier and insisted that they wouldn't be discharged until we have a verdict that the court, i.e. he, would accept. They gave in a little bit, and I think we ended up with guilty of speaking to an assembly in Gracechurch Street, but of course we still didn't have the word unlawfully. The judge had them locked up overnight, no food, no water, no heating. You probably need that that time of year necessarily. And even after 2 days, they returned a not guilty verdict, at which point the judge decided to fine them for contempt of court. The foreman of the jury, after whom the case is named, Bushell's case, Mr. Edward Bushell, refused to pay the fine, and he petitioned the Court of Common Pleas, and the Chief Justice of that court, Sir John Vaughan, ruled that a jury could not be punished simply because it returned a verdict that the judge didn't like. And I suppose one could derive from that, not necessarily a principle, but a thought that jurors can give verdicts, and indeed do, it would appear, according to their conscience. And of course, this principle has now been confirmed in the House of Lords case of Wang. Students may recall Mr. Wang, who was a specialist in martial arts. He was an asylum seeker, and he found himself one February at Clacton railway station with a bag containing some of his martial arts equipment, which I think was a scimitar and some sort of Gurkha knife. Apparently his defence was at the trial, when he was found with these objects, was that he didn't want to leave them in his flat because they thought it was dangerous to leave them in his flat, and it was safer to have them with him. The fact that he got them out at the railway station, well, perhaps is an interesting point. But in any event, the point of the case is that the Crown Court judge rejected this defence and told the jury very clearly that as a matter of law, the offences were proved, and he directed them to return guilty verdicts. So it was a very precise direction from the judge, and they did. When the case reached the House of Lords, they allowed Mr. Wang's appeal. And the committee said that there are no circumstances in which a judge is entitled to direct a jury to return a verdict of guilty because a belief that the jury would probably and rightly have convicted does not enable a trial judge to give a direction to convict. Because the Court of Appeal had posed a question: in what circumstances, if any, is a judge entitled to direct a jury to return a verdict of guilty? And the House of Lords replied, essentially, none. I think we would all admit that trial by jury is considered a fundamental part of the English legal system, even though only a tiny minority of cases are actually considered in this way. Obviously in civil cases it's de minimis, and in criminal cases something like 1%, is it, Cheryl? Though that's probably about 30,000 a year. Is it 25,000 trials a year?
No, probably more like 18,000.
15 to 18,000. So, but nonetheless, 1% of criminal cases. So it's actually a fundamental part of our English legal system, but only in a very small number of cases, though serious cases at that. And I suppose that's the point. Numerous defenders of this. No doubt many of us have read de Tocqueville's famous book Democracy in America, where he wrote, "To regard the jury simply as a judicial institution will be taking a very narrow view of the matter. For great though its influence on the outcome of lawsuits, its influence on the fate of society is much greater still. The jury is above all a political institution, and it is from that point of view that it must always be judged." Lord Denning, of course, the law student's favourite judge, famously said, of course, or wrote in a judgment in Ward and James, "Let it not be supposed that this court is in any way opposed to trial by jury. It has been the bulwark of our liberties too long for any of us to seek to alter it. Whenever a man is on trial for serious crime, or when in a civil case a man's honour or integrity is at stake, or when one or other party must be deliberately lying, then trial by jury has no equal." Most romantically of all, Lord Devlin wrote in the 50s, "Trial by jury is more than an instrument of justice, and more than one wheel of the Constitution. It is the lamp that shows that freedom lives." Well, perhaps not all of us are convinced by his romanticism. I think one could point out that this bulwark of our liberties has not prevented many famous miscarriages of justice, particularly those which were exposed in the 1990s. Stephen Downing, the Birmingham Six, Guildford Four, the Carl Bridgewater case, and so on. Many examples. And Penny Derbyshire, in her article, "The Lamp That Shows That Freedom Lives, Is It Worth the Candle?" argued, juries are not random, not representative, but anti-democratic, irrational and haphazard legislators whose erratic and secret decisions run counter to the rule of law. Derbyshire and others obviously are concerned that juries occasionally may reach perverse verdicts. They may have acted on the basis of prejudice, on the basis of stereotypes. Sometimes perhaps they will have failed to understand legal and evidential issues. And of course there are a number of examples where we presume that juries have been motivated by matters of conscience to reach a verdict. And perhaps the most famous example I think I have lived through is the famous Clive Ponting case. He was the civil servant, one will recall, who leaked confidential information to Tam Dalyell that was then passed to a journalist. He, of course, or his lawyers argued that he had exposed a matter of public interest, namely the fact that the government had misled Parliament about the circumstances in which the Argentinian warship, the General Belgrano, was sunk by a British submarine during the Falklands War. As I say, we don't know why they reached that conclusion, because they don't give reasons for their verdicts, but it is probable because they considered he had done the right thing. They perhaps saw themselves as protecting a private citizen against the oppressive use of power by the state. So for some, the ability of a jury to deliver a moral verdict is one of the system's great strengths. For others, perhaps some lawyers included, though we will see in a moment, they are perverse decisions and an affront to the rule of law.
I'm going to run through with you some of the findings that we've come up with in our research about how juries actually work. I think we've just heard a very interesting historical summary of some of the sort of romantic ideas about juries in this country, in England and Wales, and also some of the strong beliefs on some sides about juries, about whether they are fair, whether they are discriminatory, whether they're representative. And I'm really here not to speak about what I believe juries should be. I'm really here to speak about what research has told us juries are and what they do, but also to highlight some issues where we've identified that the system may need some improvement. So I've been very fortunate over the last decade, and I can't believe it's that long, that I have been spending time with juries, time in court with judges, and looking at all the verdicts that juries have returned in all the Crown Courts in England and Wales in this period, and trying to get an understanding of how the system actually works from initially summoning, the initial summoning point of juries. Is that system working? Does it produce, as it is intended to do, reasonably representative groups of people at each Crown Court, all the way through to how juries make their decisions, how they receive information in court, how judges communicate with them, and then ultimately how they reach their decisions. So it's going to be a very, I hope, fast but informative 10 minutes on what we know so far. And as I said, I'm really focusing on what do we actually know, and not what would we like to think juries are, or what are we fearful that juries are. The UCL Jury Project, it's important to note, we only work with real juries at court. So I'm very fortunate to have access to all the data on all jury trials in all Crown Courts in England and Wales over a 10-year period from 2006 to 2016. We also see juries post-verdict to ask them issues about their understanding of the case that they sat on, and also their experience of jury service. And we do some case simulation in which we have jurors look at a reconstructed film of an actual case and ask them to deliberate and reach a verdict. The important point there is that unlike any other research, we only do this with actual juries at court. The vast majority, for the students in the room, for the vast majority of articles that you will read that say jury research and this is what juries do and what they decide, most of that research is done with either volunteers from the public or students. And I think, we can all imagine that it's incredibly difficult to replicate a jury pool or a group of jurors from people who volunteer, because most people who receive a summons, or many people who receive a summons, if they were asked, do you want to do it, will probably say no. So juries are quite unique. It's a group of people, some of whom are very happy to be there initially, and some of whom would perhaps prefer to be somewhere else. But all the research that we do is only with actual juries at court. So I hope you bear that in mind with the results. So we looked at, I was asked initially by the government to look at whether the summoning system worked. So does the random selection of people to serve on juries from the electoral register, does that result in there being representative pools of people at individual Crown Courts in the country? And what we found is that actually, yes, the summoning system works incredibly well. So first of all, we found that most people in all parts of the country respond to their summons, which is contrary to, I think, it was very interesting you mentioned Penny Derbyshire's work, and she did some very good work assisting Sir Robin Ould with his review of the criminal courts in 2001. But both she and Sir Robin said that they were having to work with the absence of any empirical evidence. So we were able to come along and say, well, what is the actual empirical evidence? There was a belief that most people try to avoid jury service, and particularly in London, we found that was absolutely not the case. The overwhelming majority of people who receive a summons respond to that summons. Those who don't tend to come from areas of high residential mobility, which means they probably no longer lived at that address. Those who do, and what we found is that the majority of people who do respond also serve. Those who don't serve, as you can see, 28%, for legitimate reasons such as medical reasons, childcare, care for the elderly, and so on, or they were actually disqualified and not allowed to serve. So, I think it's a very healthy sign of democracy in England and Wales that most people, even if they wouldn't necessarily volunteer to do jury service, when asked to do it, they respond and they serve. And then the next question was, how representative are jurors? Some of you may recognize people in that photograph. This is from, I think it was a BBC series quite a few years ago, in which a group of celebrities were asked to be a jury in a reenacted criminal case. Many of the people there, I think, might be disqualified from jury service, but in any event, the reality is that we were able to map the local population dynamics of every single Crown Court in the country, and we were able to map the demographics of pools of people who did jury service in those courts, and we found that they were remarkably representative on a whole range of issues, from gender to age to ethnicity to religion, professional background, and so on. And I think I've been trying to say this probably for the last 5 or 6 years. Myths die hard, but we do have a remarkably representative jury system that works based on the way that we summon jurors. So that's some good news. But you have to then ask the question, how effective is the jury system once the jurors are there, once they're sworn onto trials and they're asked to return verdicts on particular offences in different cases? Just as one sort of measure of effectiveness, one thing we found, which I found quite surprising, but we've reanalyzed everything, and it's all the data, the results are up to date to 2016, and this result has stayed the same over 10 years. Hung juries are incredibly rare. When juries are asked to return a verdict, they do so over 99% of the time. Now, I have barristers who find that statistic unbelievable, but what we did find is that jurors are, if there is a hung jury, it's likely to occur in a number of instances. The first is that it's when jurors are presented with a number of different charges. You usually, if you're going to see a hung jury, it's usually where they've had multiple charges put to them. They are able to reach a verdict on some charges, but perhaps not on one or two. And we also found that sexual offences charges make up half of all the hung juries. So there are particular types of offences that juries find difficult to decide. But overall, juries are incredibly effective in that sense. They are able to reach verdicts. But I think probably one of the most fundamental questions is, yes, but are those verdicts fair? Do they treat all defendants equally? Are they swayed by different types of people? And I don't actually, at the moment, in this very brief sort of run through of all the research, have time to go into details of how we conducted all our studies on this issue, but I will share a few of the key findings with you, which indicate very strongly that juries are not racially biased in their decision making. This was our first study. It was published in 2010, looking at every single jury verdict at every single Crown Court in England and Wales over a 2.5-year period. And there was no significant difference in the jury conviction rate based on the ethnicity of the defendant. Okay. And what I can say to you, it isn't published yet, but I can say that the updated results of this are incredibly consistent with these results. There is no statistically significant difference in the rate at which juries convict based on the ethnicity of the defendant. And I think that we should all be quite proud of that. Most people in this country thought that the research that was done in the United States looking at this issue, which found that there can be examples of juries who do discriminate on a consistent basis, was probably also the case here. But once we did the research, we couldn't find any evidence of systematic discrimination based on the race of the defendant. What we did find, so that sort of begs the question about, well, what factors do affect the rate at which juries convict or don't convict? And we looked at a range of issues. We looked at, does it matter what court you're tried in? Does it matter what race you are? Does it matter what you're charged with, how many offences you're charged with, and so on? And the one thing that we found, and this is the result, is, and this should not be surprising, the offence with which a defendant is charged is the one factor that affects the jury conviction rate. So what you've got here is, in green, those offences that have the highest jury conviction rates, and those in red are those that have the lowest jury conviction rates. And we looked at this, and looking at the different offences and how they split, and discussing it with quite a number of people, we came to the conclusion that these results suggest that juries are trying the case based on the evidence and the law. Those in the green are offences that are likely to have some very strong physical evidence put to the jury. Those in red tend to be those offences that tend to be one person's word against another. Does anyone have a question about this? Usually there's a question that arises about something that's missing on this diagram. No? Okay, usually people ask me, yes? Yeah, where's rape is what I'm usually asked. Rape as an offence. One thing I have to say is, in this country we don't have a single offence of rape. We actually have 10, and it depends upon the gender and the age of the complainant. But if you put all rape charges together, the jury conviction rate is 55%. So it's in the middle. I think 55%. Most people would think, based on what you hear in news reports, that it's around 6 or 10%. But that's the percentage of allegations to the police that result in a jury conviction. So juries actually, sorry?
So all of those separate offences taken together, you say no different categories?
Yes, and the conviction rate varies by each of those 10 different offences. But it's not all female complainants have lower jury conviction rates compared to male complainants, or age. It's not consistent. Okay, but overall, juries are more likely to convict than acquit on rape offences. Right. So that's some of the information that we found. We found lots of other information about juries, but I just want to highlight a few things that, those are all, I think, quite positive results on the extent to which our jury system is functioning properly. And I just want to highlight a few things that indicate that where we may need to do some more work, or we are doing some more work, or there have been recent developments. Directing the jury is an issue that has come up quite a lot in the last 5 or 6 years. And we did some research which showed that when judges give juries written directions on the law, this substantially improves their comprehension of the law, which I think is something we would all feel more comfortable if we were sure that juries, when they were deliberating, clearly understood the law that they needed to apply in the case. 5 or 6 years ago, when I talked to judges about this, there was general skepticism about whether judges could or should use written directions. Many people said parties to case would never agree with it, or that it would be too complicated. I have to say now that, and David Ormond might either support or reject this thing, but I think we can say that about 99% of judges now use written directions at least some of the time. Judges don't always use them. A particular judge may not always, but judges now, I think this evidence has made them realize that juries need this. We also asked jurors in actual trials, when they had finished the case and they're about to leave court, did the judge give you written directions in your case? And if so, did you find them helpful? And this is the result. And whenever I present this result, I have to say that I've never had a 100% result for anything except this, which is 100% of jurors who received written directions from the judge said they found them helpful. 85% who didn't receive written directions said they would have liked them and would have found them helpful. Now, it begs the question whether it actually does help, but our previous research found that written directions do help. Many of you will have heard about issues involving jurors misbehaving, using the internet, looking for information about the defendant, or certainly in one case, communicating with a party to the case via Facebook. And this has raised a number of queries about whether juries can actually survive in the internet age. There is a rule in which jurors are not allowed to look for information about their case while it's going on. We asked jurors what their understanding of the internet rule is, and what we found is that 3/4 of jurors do understand the rule correctly, which is they can use the internet while they're on jury service, but not to look for any information about their case. A very small percentage are in legal difficulty. The 5% who think there's no restriction at all on their use of the internet while they're on the trial. 2% who believe they can look for information about the case as long as they don't let it influence their judgment. But actually, more worryingly, 16% are now so frightened of using the internet while they are serving on the jury that they think they can't even check their emails. What I would like to say, somewhat confidentially, is that we're currently piloting some new guidance for jurors on their legal responsibilities as jurors, and that pilot is currently going on at the Old Bailey, and we hope and we will be able to check and see following the pilot whether it's improved their understanding of the internet rule as well as other things. Deliberations is another area. We asked jurors, would you have liked more information about conducting deliberations? So these are people who've just finished deliberating and are about to leave court. Very worrying that 82% of jurors who've just deliberated said they would have found it helpful to have a bit more guidance on what they just did. And we, I didn't put it up there, we asked them what type of information they would have liked, and it's things like what to do if confused by a legal issue. I think we would all want jurors to know what to do should that arise. And things like how to ensure that everyone has a chance to express their view and people aren't pressured into reaching a verdict. Finally, I think many of you will have heard that there has been quite a significant increase in sexual offences, cases that are put to juries around the country in recent years, and that itself in some cases is resulting in jurors being exposed to some quite extreme disturbing evidence. We all have mobile phones now, and people unfortunately like to film themselves doing things that they shouldn't be doing, and sometimes that ends up as evidence that juries have to see, so they don't just have to hear about what someone's done, they may have to watch some very difficult evidence. I put the example of the trial that occurred in Cardiff a few years ago, that the defendant was Ian Watkins, who was a member of the Lost Prophets band. He was refusing to plead guilty. There was very, very graphic, disturbing evidence of his sexual offences, and that raised some very difficult challenges for the judge in that case about how do you actually ask jurors to watch that material. And as a result, there's a growing concern about juror aftercare. We generally say thank you to jurors at the end of their jury service, and we show them the door, and that's it. At the moment, the courts are working with the Samaritans to try and develop some means of providing jurors who may be disturbed by their experience with some type of aftercare. So I think that's another area for development. But I'll just leave you with, so not to end on too negative a note about things that we still need to do to improve our system of trial by jury. This is the result of a lot of years of research asking jurors as they leave court, how did you feel about your time on jury service, and if you were summoned again, would you be happy to serve? And I think it is a remarkable and quite positive statement that almost all jurors who actually do jury service say they would actually be happy to serve again, not just begrudgingly willing to serve again.
My connection with the world of the jury is initially started and has predominantly been with civil juries, because as a libel defamation practitioner, up until a few years ago, libel trials were conducted in front of juries, although that is no longer the case. So it was only when I became a Crown Court recorder, something which I stopped doing in 2015, I think it was, that I came to have some contact with criminal juries, or juries in criminal trials. But the one thing that I have to confess to you is that I ought really to have served a suspected sentence for contempt in soliciting the information or the details of jury discussions. Don't make a note of this. I was, a long time ago when I was first at the bar, I was instructed along with Lord Rawlinson and Richard Rampton to defend the Daily Mail against an allegation of libel brought by the head of the Moonies, the Unification Church in England, a chap called Orme. The case is called Orme and Associated Newspapers. And that was the longest civil jury action, I think, possibly ever, but certainly in the 20th century. It lasted from October right the way through till the following May. And we started off with 12 jurors. In front of Mr. Justice Cumming, we appeared. And it was quite clear that the jury was getting increasingly fascinated by the case, and particularly when I was allowed to cross-examine. But broadly, the claimant, the plaintiff's case lasted from October till Christmas. Then we broke over Christmas. One member of the jury asked for permission to go because this was going on far too long. He found it all rather tedious. And anyhow, he had a farm to run and a business to run, and would it be all right if he went away? So he could only do that with the consent of the parties. We consented. We didn't want an angry jury, and we certainly didn't want to start the whole thing again. After Christmas, the defence case started, our case started, and of course, coming in and out of court in the Royal Courts of Justice, getting on with your work as the baby junior, your attention wanders and you look to see whether the members of the jury are interesting or paying attention. And after a while you can see the sort of good body language going on between various members of the jury. And then by April, or I think it was about April, we got the verdict. We won the defendant case. We won, and we all went back to Lord Rawlinson's room to celebrate, and then back to our various chambers. When I got back to my chambers, a telephone call came through, and my clerk said, "There's a telephone call for you from a woman." So I said, "Well, that's very nice." I was 28, unmarried. A thoroughly suitable thing for a barrister to do is to take a telephone call from a woman, even if I didn't know who she was or what her name was. Anyhow, it turned out she was a member of the jury, and she thought it appropriate to be met for a drink. So I said, "Well, I'll ring you back." So I rang Peter Rawlinson, my leader, and I said, "I've just had this extraordinary telephone call. What should I do?" He said, "Go." but take a note. Anyhow, it was quite clear from what this young woman had told me that, first of all, that she was a reluctant juror. She was effectively on her gap year. She was a New Zealand woman of age about 21, 22. She'd come over to England, staying with her aunt in London, and I think she stupidly got herself onto the electoral roll, or somehow drew attention to the jury system. And she was stuck there. Her gap year was more or less ruined by spending 6 months on a jury. But she told me that there were 2 sets of people on the jury who were, by Christmas time, were holding hands. That by the first month, after the first month of the trial, they were pretty convinced by the plaintiff's collective evidence, but by Christmas time, they decided that this case was going nowhere because the plaintiff's witnesses were contradicting what earlier witnesses had said. And really they could have produced a verdict by Christmas, but there was no way that they could have stuck their hands up and said, can we all go home and fine for the defendants? But the strange thing was that this was, of course, pre the 1981 Contempt of Court Act. I suppose I could have been done for criminal contempt or buying someone a drink and not paying for it. But the thing that I gained, I think, from my working with juries in civil actions is that there is a sort of collective common sense. I've got no way of proving this to Professor Thomas's satisfaction, but in the many civil jury actions that I have appeared in, sometimes you agree with the verdict, sometimes you disagree with the verdict, but annoyingly there does seem to be a system of common sense which develops, and one never knows whether they have rationally analysed the evidence and considered the directions of law, whether they like the barristers or the advocates, or whether they find the judge annoying or whatever it may be. By and large, we tended to feel that although the result may be disagreeable, it was probably the right result in most cases. I obviously, once I became a recorder, had to sum up to juries, and sometimes I gave written directions, particularly over things like self-defence, which even I find complicated, so it must have been fairly complicated for the jury. And it's actually quite a relief, if you are sitting as a judge, to be able to hand over, in plain English, a direction which explains the law. To what extent they pay attention to it, I don't know, but obviously your research suggests that it is a very useful thing to have done. But certainly as a judge, I found providing written directions on complicated areas of criminal law a great help. And it also clarified the issue in one's own mind as one was trying to direct the judge. So it was a discipline for me, as well as I hope an aid to jurors. Probably the most interesting, certainly from my point of view as a practitioner, element of the criminal jury system that I came across was when I was Solicitor General and had to prosecute Mrs. Frail. She was the woman on the top left-hand corner of Professor Thomas's slide there. She was the Facebook jury woman. It was a very, very sad and silly case in many respects. This was the third iteration of quite a complicated drug conspiracy. The first two trials had come to a grisly end, and this was the third attempt at trying to prosecute the half a dozen defendants. And some on the third occasion had been acquitted, some were still awaiting verdict. When Mrs. Frail on the jury, I think probably because she genuinely felt sorry for all of the people in the dock, and particularly for the woman called Jamie Stewart, who was one of the co-defendants who had been acquitted, but whose boyfriend and the father of her child was still awaiting a verdict. She started to Facebook her, fatal, and she ended up getting 8 months from the High Court. And the experience that she faced was appalling. I mean, she was I don't mean to be condescending, but she was an ordinary Greater Manchester woman of mid-40s, I would guess, who had probably had no contact with the criminal justice system, certainly never sat in a jury before, and yet written directions on law are helpful. All over the jury room were things saying, do not do the following. The judge himself, the trial judge, said more or less every other 20 minutes, please don't research this case, please don't use mobile devices or internet devices to do improper things, and yet she still did it. So whether this case is peculiar to her or whether other members of other juries might be tempted to do this, I have absolutely no idea. But it isn't only, shall we say, less thoughtful people who do this. And the other lady you could see in this slide was an academic called Dallas. And there was a woman ostensibly very bright, but clearly one must never fail to distinguish between intellectual ability and common sense. And she did broadly the same as Mrs. Frail, say that she was investigating into the internet world about the defendant. Well, she fell into error and got a prison sentence as well. It is extraordinary how these people who ought to know and who were told not to do what they eventually went on to do, didn't seem to draw a connection between the acts that they committed and the consequences of those acts. An academic, highly intelligent woman just simply did not think that she was going to be, if convicted, once the contempt process had started, that she was going to end up with a prison sentence. Mrs. Frail probably didn't think quite so hard about the matter, but again, all around the room were things telling her not to do all that. Now, following those cases, we then got David Ormrod and his colleagues at the Law Commission investigating the law of contempt, and particularly one of the chapters dealt with jury conduct. And it led to amendments to the law through the Criminal Justice and Courts Act of 2015. And now all of those things that Mrs. Frail did, and that I don't know whether she was a professor, but anyhow, Dr. Dallas did, are covered by sections of that 2015 Act. But I have a suspicion that there will still be people, contrary to the instructions of the judge, contrary to the instructions put on the walls in jury retiring rooms or waiting rooms, contrary to the warnings of jury bailiffs and jury managers at courts. There will still be people doing this because they can, and because they are unclear or fail to appreciate how serious it is to undermine the integrity of the jury system. To my mind, as a politician, I support juries almost as a matter of gut and emotion rather than through intellectual analysis. I like juries. I think they are English. I think they are a way of distinguishing our justice system from other jurisdictions. And I think by and large, I think complacently perhaps, but by and large we get the jury system pretty well right. Of course, there are others who would say that complicated cases and attempts were put forward in the 2003 Criminal Justice Act to permit complicated fraud cases, for example, to be removed from a jury and to be tried by a judge alone. The 2003 Act is one of my favourite acts. Huge, it's about the size of 6 telephone books. But even by about 2006, 2007, 2008, about a third of its provisions had yet to be enacted. Another third had been enacted, and a further third was repealed before it came to be enacted. And the provision about removing complicated fraud trials from juries was one of those, which was repealed eventually in about 2010 or 2011 under the Responsibilities and Freedoms Act, a very Orwellian title for an Act of Parliament. But it strikes me that enthusiastic ministers produce, or are persuaded to produce, bits of legislation which sit on the shelf and eventually get repealed, or replaced, or imposed upon by exactly the same piece of legislation but in a subsequent act. So hidden away in this waffle is a plea for Bob Neill to be more aggressive in holding the government to account, in making sure that it doesn't pass provisions to do with juries or anybody else that it hasn't taken seriously and ought to think about more carefully, and which are either enacted or will never even brought to Parliament for discussion at all. But if we are to have a jury system, and I believe we should, as I say, for gut reasons, emotional reasons, as much as for intellectually analysed reasons, we have to protect the integrity of the system. If the jury system is to remain within the confidence of the British public, we have to make sure that people don't misbehave. And in an age of internet, in an age of absence of confidentiality, in an age when there are no secrets, it is increasingly difficult to maintain the integrity of the jury system. But I do think that advocates, judges, academics, and members of Parliament, and indeed I hope commentators and members of the public, insist upon jurors being hit hard when they break the system, because they do a lot more damage to the integrity of our criminal justice system by doing so than they cause themselves personal inconvenience by going to prison for 8 months.
This is actually a rather intimidating occasion from my point of view, because I was actually at LSE taught the English legal system by Michael Zander, who is sitting in the back there, and of course included a good deal about the importance and the very basic nature of the jury system to our own system of common law. So I've got to prove to Michael that I was listening and that I did take it in. And then when I practiced in a much more sort of bargain basement type of law than Edward did. I was a criminal practitioner. You could call me a sort of criminal hack, knocking around, doing jury trials for 25 or so years around London and the South East mostly. On a number of occasions against Jeremy Dean at Snaresbrook Crown Court, and sometimes co-defending with Ivan Lawrence, who's here today, in a range of crime. And some of those cases, it was clear the juries struggled, but my conclusion is at the end of the day, where things potentially created difficulty wasn't the nature of the jury system that was at fault. There were other things. And I share the view that on a common sense basis, juries by and large get it right. I'm going to say I too have a jury story. And I don't want you to think that all barristers are prone to this sort of misadventure. But as a very young and rather slimmer junior tenant in my chambers, I happened to be doing a case not in my normal part of the world, but in Birmingham, where Jeremy is doing one at the moment in the old Victoria Law Courts. Only because my client, who was, I think what Rumpole would have described as a good little provider, had been thrown out of his South London normal residence by his girlfriend, and had decided to go and work on what was then called the lump in the West Midlands, and was accordingly brought to book for this. And after a trial, he was convicted by the jury, which did not entirely surprise me on the evidence, and it was the last day that the court was sitting before Christmas. I was making my way out of the court, having seen him in the cells. Again, a not entirely unfrequent experience between myself and this particular client, and the jury were just being sort of paid off their expenses, and on the jury there was a very attractive lady of a certain age, perhaps a little older than myself, very smartly dressed, who came over to me in smiling fashion and said that she thought I'd done a jolly good job given what material I had to play with. Very kind of you, thought I. Are you getting the train back to London? Well, I am, but I'm not sure what the times are, and there were some delays. Oh, she said, well, why didn't you come and have a coffee? I thought no more of this. I thought, well, maybe. It was a similar response, no doubt, to Sir Edward under these circumstances. It then transpired that she told me that her husband, who was a successful businessman, travelled a great deal. And that when he was away, she frequently came to London. And gave me a telephone number. Now, being a very new junior tenant and anxious to make my way at the bar, I naturally thought hard about the professional etiquette surrounding this matter. So having eventually got back to chambers, well into the evening by that point, I sought out my then head of chambers in Elvino's. And I said to him, Eric, I've got this ethical problem. This woman may well ring me up in chambers, or she'd give me this phone number. What should I do? And he said, 2 things. Don't do anything drastic until you've had time to put in your grounds of appeal. And secondly, on no account have any discussions about how they came to the verdict. And I suppose that was a rough and ready, not bad bit of guidance from dear old Eric Myers at the time. But when you pull that together, it leaves me with this conclusion. I think the analysis that's been done is pretty clear. Jurors do sometimes behave in odd ways, sometimes they will behave in slightly irrational ways. But it's a human institution. And most human institutions are prone to occasionally rash, irrational behaviour. Parliament, heavens above, is, dare I say, not above that. Magistrates, judges sitting alone, perhaps not entirely above that. I don't know if anybody here flies British Airways, but I won't go further down that sort of comment. But any institution is capable of making error. But when you look at it in the round, does it work overall? I suspect it does. And quite interestingly, I think when we were looking at those very good pieces of research as to why juries sometimes struggle, it very much actually coincides with my own experience in matters, because I did crime throughout the whole of my time at the bar. Doesn't surprise me, for example, that attempt murder is low down the list. Doesn't surprise me that threats to kill are well down the list, because very often I suggest it's the nature of the ingredients of the offence which will give juries difficulty, not the fact that they're being tried by a jury as such, and therefore the mental element in particular. Distinction between murder, attempt murder, murder, manslaughter, and so on. What the mental element is in threats to kill and other things of that kind, Section 18 GBH to a lesser perhaps degree as well. That's really what it is. So we can't blame the jurors for having sometimes a bit of difficulty grappling with the elements of the offence that Parliament has enacted. The answer is maybe to see if the elements of the offence work, or as is, I think, increasingly the case, help them in the way which judges now do with those written directions. And a good example, actually, that the Justice Committee has looked at was the law around homicide. And David Ormerod's Law Commission have come out with some very excellent proposals to revise the law around homicide. And one of the reasons for advocating that is that there's some evidence there that juries do have some difficulty with those distinctions between murder, attempted murder, and manslaughter. And frankly, a simplification and revision of that, moving away from what are distinctions which are difficult for them, perhaps even to a system of categories of manslaughter, would have benefit. Now, sadly, despite the recommendation of our committee, which thought there's much merit in David's proposals, the government hasn't chosen to go down that route. I think they're wrong. But again, the error there lies not in the jurors and lies not in the jury system. But it's the hand that we, as legislators, have dealt. And I think we could all probably think of a number of other cases that come to the same effect. And then the other reason that I think is important is the point that's made about it as a social and political institution. It is about the involvement of members of society in the criminal justice process. And that's, I believe, of profound significance. Not only because it's a means whereby citizens fulfil a civic duty, and if you like, buy in to part of what we do as a society, in an active rather than a passive way, but it's also important, it seems to me, in terms of justice being carried out by consent of society as a whole. And that works in a number of ways. It's the involvement of members of society which gives them the chance to say, we, ordinary individuals, consent to this system operating, because we have some faith in it that it is done by people like us in the appropriate cases. I'd also suggest, funny enough, it's quite important to have a measure of consent from those who are tried by the jury system. And quite often, the fairly hardened criminals that I prosecuted or defended were actually believers in the jury system. And in a sense, they bought into it. They accepted that sometimes being convicted was, as Norman Fletcher said in Policy, an occupational hazard. But there was consent because they had some faith that ordinary people, and they had the chance to, if they wanted to, put their case to a jury of ordinary people, and if they weren't believed, well, there you are. I wonder if you'll get that same result if a judge seen as being, in effect, a member, rightly or wrongly, of an establishment, was doing that without the jury in those sort of cases. I suspect not. And that's important, particularly nowadays, because one of the issues that we all as politicians have to grapple with is a sense of alienation and disinvolvement in society by many people. The jury system in its way, its weigh in its small number of cases in total, but as an institution helps, I think, to break down areas of alienation and gives both the public a buy-in to the system, gives defendants the sense that it is not purely done by them to us, but actually us have an involvement in it. And I think that's immensely valuable. So for all of those reasons, I'm a fan of the jury system. The best thing politicians can sometimes do is conclude, if it ain't broke, don't fix it. An injunction more often honoured in the breach than not, as Edward has pointed out with some legislation. As to whether or not the Justice Committee is being sufficiently aggressive, or I'm being sufficiently aggressive with ministers, I'll leave to the distinguished legal journalists and commentators here to judge. I think I was described as avuncular in one tweet, but that was when I was cross-examining the Lord Chancellor. I thought that was only fair in the circumstances. But I think we're not afraid sometimes to show our teeth when the moment arises. And of course, what we're doing there, in a sense, is seeking to persuade a much broader jury of public opinion to a particular case. So I'm delighted to put forward a few thoughts of mine, and suffice it to say, I lost the phone number.
Still, from the point of view of a practicing criminal defence barrister, with some of the things that make me such a strong supporter of the jury system, even though, as someone who has only ever defended, my rate of success before juries is not particularly high. I'm also a Crown Court recorder and have been since 2014, and obviously rate of success there is completely irrelevant. I am currently in a murder trial at Birmingham Crown Court, and it's quite useful for me very briefly just to encapsulate those circumstances. The case in question involves an allegation of murder against a black defendant who is said to have killed his partner in 1981. The jury are all white, and the case involves very complex issues. It's been going on for 6 weeks. DNA evidence disputed, so giving rise to serious contested forensic issues, a disputed confession under the pre-PACE regime, where a full confession is said to be made by the defendant, unsigned, hotly disputed by the defendant, a confession said to have occurred during the time of the Birmingham riots in 1981, being tried by a jury at Birmingham Crown Court in 2017, and some 30 background witnesses who are said to have made statements incriminating the defendant under pressure from the West Midlands Police, subsequently disbanded to a large degree in the 1980s. That all-white jury has been in retirement for 6.5 days in the face of that evidence. And although I may slightly change my view about juries tomorrow, if the verdict comes tomorrow, it's testament to the jury system that that jury is still in retirement, rightly in retirement, in the light of the complex and controversial issues 6 or 7 days later. And when I think back to the days I used to be against Bob at Snaresbrook back in the 1980s, we as practicing barristers, criminal barristers, had confidence in the jury system then, and that confidence hasn't altered one bit from those days back in the 1980s through to 2017. No one at Birmingham Crown Court has the slightest doubt that this jury, no one who knows anything about the case, including the judge, that this jury is dealing with this case efficiently and effectively and fairly and rigorously. And that's why they are in retirement tomorrow for their 7th day. Just shooting through the issues that have been touched on this evening, and the ones that are highlighted in the sort of introduction to this evening's event. What is the position with regard to, as I see it, the effectiveness and efficiency of juries? Well, I think juries are incredibly efficient. And obviously I've read the fantastic research that's been touched upon this evening before, and that corresponds very, very closely to my own personal experience.
juries are efficient. Trials run as efficiently as they can. If they aren't efficiently run, that is because of poor case management or problems in the case, but it very rarely has to do with the jury itself. In the case that I'm doing at the moment, over a period of 6 weeks, the jury have been at court at 10 a.m. every day. There hasn't been a single day when the jury has been late, and there have been no difficulties whatsoever. The jury has been in retirement and asked a series of highly pertinent questions relating to various aspects of the evidence, and I've said what the categories of evidence are, and no one has suggested in the course of what is a classically difficult case that the jury have been anything other than highly efficient. Are juries effective? Well, I venture to suggest that juries are effective. I agree with everything that's been said about jury verdicts tending to correspond with expectation. Although I don't do much fraud work myself, many people in my chambers do, and it's often commented on how remarkable it is that even in multi-count fraud indictments, juries get the verdicts right. And that is clearly testament to the efficiency of the jury system. And these days, there are measures taken, such as extra jurors being present for prosecution opening, just in case there are problems during the opening which result in the need for juries to take over, and so many different measures adopted during the trial along the lines of special measures, TV link, breaks being taken very regularly, and of course, and in particular, written directions, steps to verdict, and an aspect of the procedure that I strongly advocate, which is that legal directions being given to juries before closing speeches, so that juries can assess what the law is before the facts are canvassed before them, that in my view make juries even more effective in their approach to factual issues. Do juries fully understand their role? That's another issue that's been raised for our consideration. Well, to some extent I've dealt with that, but I'm firmly of the view that juries do understand their role. The role in itself is, of course, very simple. It is to reach a just verdict. And there's no ambiguity about that, and there's no difficulty in juries following that. And again, the research that we've been told about tells us, and it's my own personal experience, that juries fully comprehend, if it needs to be explained, and it often doesn't need to be explained, but it's clearly important, that issues of emotion, bias, racism cannot be factored into the decision. And as someone who essentially does violent crime and represents people from the ethnic minorities, largely from the ethnic minority communities, I do not see racism in juries, and I haven't seen racism in juries for a very long time. Indeed, I simply don't identify racism as a feature of the jury. I can't necessarily say the same about the judiciary. It's improved radically, and it's improved beyond all measure. But I think we saw in the press a couple of weeks ago that there's still a sense that sentencing, perhaps, and other features of the criminal justice process can be influenced by, perhaps unwittingly, by racial considerations, although I stress that my own experience is that the judiciary has improved immeasurably and unrecognisably from what it used to be. But where juries are concerned, I simply do not detect and can't remember really ever detecting any form of racial bias, and their ability to identify the role to return verdicts impartially, effectively, efficiently and fairly is paramount, as in my experience over the decades. Are they able to interpret judicial directions and respond appropriately to what they're told to do by judges? Well, I'm firmly of the view that written directions are a major positive development, steps to verdict, the clearest possible guidance in writing. But I totally adopt what Bob has said a moment ago, which is that where there are difficulties, say for example in the ingredients of offences, or Section 34 directions which relate to the right to silence, which is a direction I know David's worked on to improve, that any difficulties are wholly attributable to the legislation and sometimes to the way in which judges give directions. and sometimes it's very difficult to give comprehensible directions. I have to do it myself because the framework just isn't sufficiently straightforward. But juries are on the receiving end of these complications. They're not creating the difficulties themselves. And it is testament to them that despite what sometimes can be almost incomprehensible directions, that generally speaking, verdicts are, as I've said, as expected. So it's clear how I feel about the jury system, and that just drawing together and concluding in relation to the comments that I have to make. Again, if I may just adopt an observation Bob made, and it's something I feel very strongly about as someone who has always represented people charged with crime, and over more recent years very serious crime, that it is my personal experience, and I absolutely endorse the observation, that on the whole accused persons respect the jury system and are far more amenable to accepting the decisions of juries than they are the decisions of judges. And that distinction can be drawn in the jury trial as between factual findings and legal rulings. So of course an accused person may be less able to understand a legal ruling, but hopefully it's explained. But generally speaking, during the jury trial, defendants become far more animated about what they perceive to be unfair legal rulings than unfair factual findings by a jury. And it is right, and I wholly agree, that, and it's quite conceivably my principal reason for supporting the jury system, although it is a deficiency that juries do not have to give reasons, but that is perhaps simply a practical consequence which can never be addressed, that when a person receives is on the receiving end of a negative verdict, and in particular a long sentence, and quite often, certainly in the stuff that I've done over recent years, a life sentence, there is a feeling that that individual has had the opportunity to put his or her case before their peers, and that does appear to me to make the system work far better, and accused persons accept that result more easily. And for that reason, and all the other reasons I've given, I am a fervent supporter of the jury system, and I hope that it goes on and on, because without it the criminal justice system would be a pretty wretched place, I think.
I want to thank EPP for hosting us, and all our panel particularly.